We have a range of interviews covering topics that came through, particularly from the courts in the last few days. So let's bring this into perspective. Judgment has been reserved in the Democratic Alliance's court challenge against the Employment Equity Amendment Act. The party wants the amended act to be declared constitutionally invalid on the basis that it gives the Minister of Labour the power to set sectoral employment equity targets that the party says amount to racial quotas and are rigid and would worsen the country's unemployment crisis. The case has triggered the debate over whether the DA is opposing this specific modality of employment equity or the concept itself, despite its provision for measures to advance segments of the population affected by patterns of discrimination, and those are provided for in the Constitution. So joining me now to unpack these questions, let's start now with Dr. Nomfundo Ramalekana, who is Senior Lecturer in Public Law at the University of Cape Town. Good afternoon, Doc, and thank you for your time. Just your overall impressions watching the debates in the court and the arguments being presented by both sides to this debate. The starting point, I suppose, is that these measures to advance people affected by historical disadvantage are rooted in the Constitution, but this particular modality is what is being debated. What did you make of the debates and submissions?
Thank you so much, and good afternoon to everyone. So at the core of the DS challenge are four broad arguments, and I think the first one is the one that I think most South Africans would be interested in talking about, and the question of whether or not the sectoral targets that are introduced by Section 15A of the Employment Equity Act amount to rigid and impermissible quotas. And then the second argument is whether or not these sectoral targets essentially violate Section 22 of the Constitution, which is the right to freedom of occupation, trade and profession. There are also two other arguments, and those relate to whether or not the power that's given to the Minister of Labour and Employment is vague and broad in a manner that essentially would be a violation of the Constitution, and finally whether or not the process through which this particular piece of legislation was enacted is in itself constitutional. And I think what I can opine on is on the question of whether or not they will succeed on the arguments as to whether or not the sectoral targets are a form of an impermissible quota. Now, as the state has argued, the use of targets is not new to employment equity legislation. The Employment Equity Act itself, prior to the amendments, already allowed for the use of numerical targets. What this new sort of amendment does is it gives this power to set sectoral-based numerical targets to the minister. The argument is that these sectoral targets are a form of impermissible quota. Under the Employment Equity Act, the use of quotas is impermissible, but the use of numerical targets as well as preferential treatment of designated groups, and this is defined as including women, persons with disabilities, as well as those who are classified as being black under legislation, which is inclusive of those who are classified as African, Indian, coloured, as well as following a judgment from our court, Chinese, South Africans. And so what the courts have said is that numerical targets in and of themselves are not unconstitutional. They are permissible, but it is when they are implemented in a manner that is inflexible and is rigid that they then become quotas. Yeah. And this is sort of the core of the argument.
Yeah. In fact, while you are on that point, let me welcome Michael Bagraim, who is a member of parliament for the Democratic Alliance, a long-standing advocate for labor rights, of course, but he is with the DA and has been instrumental in bringing forth these processes before court. Michael, good afternoon. So just the way I read it, your attack on this piece of legislation is two-pronged. There's a main challenge that speaks to the substance of the provisions, then there's a technical challenge. Step by step, let's take our viewers along with us. Take us through your main challenge. What about Section 15, capital A, doesn't sit well within the scheme of the Constitution, including the provision that provides for measures to be taken to advance people affected by historical, discrimination?
Didn't really catch much of the argument for some reason or other, the sound wasn't working. But let me explain to you what the Democratic Alliance has done. They've challenged, as you are quite correct, they've challenged Section 15, capital A. And that section specifically is not targets, it's quotas set by the minister. Now, when you look at, there's a principle in law now known as the Darwood principle, where it would have to be basically fair and would have to be intelligible and clear. And there must be certain legal standards. Now, the bottom line is that these targets, quotas, sorry, not targets, these quotas are set hard and fast, knocked into stone by the minister. Now, in the past, they were obviously, people could take into account all sorts of issues such as the availability, such as the business, such as the economy. There are all sorts of things that could be taken into account. Now, this is not taking it into account. It might take it into account in year 1, year 2, but you have to, in year 5, you have to hit that target that the minister has set. And we're saying that that's unfair, absolutely unfair. And the Constitution talks about everyone having rights, and those rights should be protected. Now, I understand that we need to have an equity in the race relations in South Africa, and we should be reflecting the demographics in every single business. We should be reflecting that, and that's understandable. But every business is completely different. Every industry is completely different. Every province is completely different. And this is somehow thumbsuck the minister, and I can't blame the current minister, unfortunately. I'd like to blame her, but you can't blame her because she's inherited these quotas that have been set in stone. And we're saying these quotas are unfair discrimination. And when you have fair discrimination, the court wants to see you, as a government, discharge that onus of showing why you can actually have this and why it should be fair to have it. And of course,
let me challenge you on an aspect that you've raised there, Mr. Bagraim. The argument that these targets are rigid in the way that they are going to be implemented. Subsection 3 of Section 15, capital A, subsection 3 talks about may set different numerical targets for different occupational levels, subsectors, or regions within a sector. But added to that, there's the argument that says a company that is not able to meet the targets has the opportunity and ability to advance reasons why, reasonable reasons why it is not able to meet those targets. How does that sit with your argument that they are rigid? Some people will say that's pretty flexible.
No, not flexible at all, because they're rigid targets at the end. Yes, in year 1, you can say that I can't reach it because of X, Y, and Z. Year 2, when you get to year 5, you have to hit that target. Now, the minister, and when you read it out to me, yes, the minister has set the targets, and she has set the quotas. So there you have it. It's there in stone. And it's entirely up to the minister now whether she wants to change that or not. And she hasn't. She's got it there, and it's set. And on year 5, you have to hit that. Yes, how you get there, there might be reasons as to why you can't in year 1, why you can't in year 2, why you can't in year 3, why you can't in year 4. Year 5, you must hit that quota, regardless of what it is.
Okay,
and
let me
you
bring
are
in
now
Dr.
relying entirely.
Dr. Ramalekana, Dr. Ramalekana, I see you shaking your head vigorously. What in this argument about rigidity versus flexibility do you not agree with Michael Bagraim about?
So I think it's inaccurate to say that by year 5, if you've not met the sectoral targets, you will be found to be in breach of the Employment Equity Act. as the courts have repeatedly held, the court will take into account the range of factors listed in Section 42 of the Constitution, which includes whether or not you've met the sectoral targets, as well as whether or not you've taken suitable steps to train your designated employees, whether you've taken significant or reasonable steps to provide for the promotion and the appointment of people who belong to those designated groups. So sectoral targets and meeting them is only one of the factors that will be taken into account when an employer is being subject to the question, are you in compliance with the Employment Equity Act? And so on that basis, the argument that you must, by year 5, have met these targets or you fall foul of the legislation is not accurate. In addition, our courts have made clear that the mere fact that there is a sanction, and again here referring to whether or not an employer will be able to contract with the state or the possibility of them being imposed a fine, isn't sufficient to say that a numerical target is a quota. The courts have said that you need more than just saying that there is a sanction for non-compliance for permissible numerical targets to be converted into an impermissible quota.
Yeah, Mr. Bagraim, I don't know if you want to come back to that. I suppose if I can add, are you able to pinpoint me to where within the provisions of this law, you don't have to quote a specific section, but perhaps where to start looking for the argument that says you can advance reasonable reasons why you are not able to meet the targets, but whatever you argue in year 1, year 2, year 3, whatever your arguments for why you can't reasonably meet these targets, by year 5, within this sector, you need to have made these appointments that align with the targets as set. Where would I find that?
Well, I don't have the law in front of me, and also I can't hear what the guest is saying, the other guest is saying at all. I don't know why. I'm completely cut off on that, which is a bit of a problem. I'm not sure what the argument that she raised. But what I can tell you is that they've got the quota, and the quotas the courts have struck down always. Every single court in the history of this country has struck down quotas. Now, that is a quota. And to call it a target is a misnomer. There's a figure. What the minister should have done, and we don't need 15A because we've got the law already. What the minister should have done was said, look, we're going to be harsher. We're going to be looking at it more carefully. We're going to test your argument. Why do you have to bring in this now? Because the minister can say this, and I'm thinking of targets. I'm happy to hear what you have to say, and I'm happy to have it properly tested, but this is not a target. These are quotas. These are set in stone. And if the minister says, no, don't worry, if you've got very good reason because the economy is shrinking and your business is shrinking, well, don't worry about it. Well, that's not anywhere there, and 15A doesn't read that way at all. If, in fact, the government is now arguing, and they're quite happy to stand by that, that this is not a quota, that you don't have to reach those targets if you have very good reason not to be able to reach them. Now, we know the economy is shrinking. We know that people are not employing. And we know that to go and reach those targets, you're going to have to either retrench people, you're going to have to restructure your business or close down. And in fact, this is what the business community is now saying.
Let me ask
the only reason why, I just wanted to say, the reason why government has now said under 50 employees, you don't have to have anything to do with the legislation, you're exempt from it. And the reason why they're saying that is that they realize that the whole idea of these targets are going to destroy the business community. They realize that, and they don't want to destroy the small businesses.
But is that really the case, though, Mr. Bagraim? Isn't it to do with the flexibility afforded smaller businesses, the regulatory compliance, burden that smaller businesses? So, for instance, if you're an employer that employs 300 people, it's conceivable that within those 300 people, you could designate 5 as a department that's simply responsible for compiling these employment equity compliance certificates yearly. And you have that flexibility. But if you're employing 20 people, that's going to be a burden on you. Isn't that the reasoning, that it's about the regulatory burden of not necessarily the substance as a concession as the way you see it, that they see it as going to destroy businesses?
Absolutely not. In fact, I don't think government's ever worried about how you're going to comply with regulations. What they're worried about is destroying the small business sector, and that's the sector that it actually is creating jobs. Big businesses have got jobless growth, and we're seeing that jobless growth across almost every industry. And that's the reason why big businesses are going to struggle to try and meet these targets that have been set and cast in stone.
All right.
If the minister wasn't going to set those targets and said that I'm going to judge each business separately, well, then there's no need for 15A anyway. Why is there a need?
Dr. Ramalekana, is this a concession, the exemption of businesses that employ 49 people or less from having to comply with these targets? Is it a concession, as Michael Bagraim says, that this is going to destroy businesses?
Absolutely not. And I think the argument that you've made is exactly sort of, in most areas, smaller businesses are given regulatory leeway to actually enable them to grow, to restrict or to remove red tape, to enable those industries to flourish, right? So in essence, that sort of requirement that businesses that have fewer than 49 is helping smaller businesses, enabling them to grow, alleviating the burden to comply with a range of different regulatory requirements. And this is an ordinary thing that happens in sort of the regulation of businesses, not just in the context of employment equity. Now, if I'm allowed to, I really just want to respond to the fear-mongering related to the argument that people are going to be retrenched in order to comply with the amendment to the Employment Equity Act. In fact, our courts have made it very clear that employment equity cannot be used as the basis to retrench workers. Again, employers will not be able to rely on any provision of the Employment Equity Act, including the amendment, to justify the retrenchment of employees.
And while I stick with you for a moment, Dr. Ramalekana, marry this and this whole concept of where we are with the amendment to the provision in the Constitution that's always cited, Section 9 and subsection 2. Can this be justified, all of these measures being taken now, given what has transpired since the Employment Equity Act was first promulgated? I was looking at the report recently of the Employment Equity Commission, and if you don't mind, I know it's a convoluted question, but just bear with me for a second. Part of what it talks about when it talks about top management level by population in 2023, it says the white population group represented 62.1%, and the Indian population group represented 11.6% of all positions at the top management level, which is significantly higher than their respective economically active populations, EAPs, whereas the African population group with an EAP, economically active population of 80% accounted for only 17.2%. And it continues, and they've got a graphic that they've produced there. So make that link for me, please, between what the measures are being taken now with that imperative from the Constitution.
Yeah, so I think it's important to note that we're seeing the importance of these measures in the private sector, especially because when you compare that 62% of the private sector top management levels still being white males to what's happening in the public sector, 74%, sort of more broadly representative of the demographics in South Africa, we're seeing that the public sector has actually been doing quite well in implementing employment equity while the private sector has been lagging behind. Now, there is this imperative in Section 9 of the Constitution to redress historic disadvantage through a range of different measures, which includes affirmative action. Our Constitutional Court, very early in its life, in a judgment by now retired Judge Moseneke, made it very clear that these measures are not only constitutional, but they are necessary to redress these historic patterns of the exclusion of Black women as well as of disabled persons from the labour market in South Africa. Now, when we're seeing these figures from the private sector, which you've just quoted, it's quite clear that those goals are not being met in the private sector, necessitating new creative ways of trying to push for the actual achievement of that goal that is set in the Constitution.
And I cited just top management. There's actually senior management, middle management, which I could have have gone into, but in the interest of progressing this conversation, I didn't. Michael Bagraim, let me pose the same question to you. You're starting to hear a few commentators. I heard the argument being presented that it's becoming harder and harder to not come to the conclusion that the DA is not supportive of this provision in the Constitution that says equality includes the full and equal enjoyment of all rights and freedoms. To promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. You're starting to hear from some commentators, granted not universal, but some commentators that are starting to say the only reason you're doing this is that you don't support this particular part of the Constitution despite supporting other provisions of it.
That's absolute nonsense. Of course it's nonsense, and I'll tell you why. We've had 27 years of employment equity on our statute book. And those 27 years have not been in any movement, and that's about the only place where I can agree. They haven't seen any movement. So what you're doing is you're taking exactly the same experiment. You're tightening the bolts, yes, but taking the same experiment and hoping to see a different result. Now, what I'm saying is the Msaneki judgment is correct, and we agree with it in the sense that you must take measures, but then you have to see results. If you're not seeing any results, then you're not taking any measures, and therefore it's unconstitutional. What we're saying is you've got to go back to the drawing board, do the hard yards, and actually make sure that what you're implementing is something that will bring about proper redress and a proper reflection of the demographics of South Africa. It's gone worse. Everyone's saying it's gone worse, and you're now blaming the business community for that. I don't know of any business that said, I'm not employing people because they're black. I'm not employing them because they're women. That doesn't happen. Everyone wants to do business with the government. It's the biggest employer, yes, but it's also the biggest user of everything else in this country. And no one wants to say, I don't want to do business with the government. So the whole argument is fallacious. What you've got is legislation in place for 27 years. It hasn't worked. Everyone agrees it hasn't worked, including the minister and government, and including our other guests that we've got here. And now we're saying is, okay, we're going to use the same thing. We're just going to tighten the bolts and we're going to make the fine higher. What you're doing is you're saying to businesses, don't invest in this country, invest elsewhere, move away, outsource your whatever you need. Don't produce it in South Africa. That's what you're really doing. And I can tell you in the next 27 years, what we'll have is no business at all, like we've seen in many other countries.
All right, let's leave it there because of time. I'm completely out of time, but I've enjoyed this discussion, and I do get the sense that we are not going to be able to settle it here. And so we will all be better for the outcome of the court challenge once it's been delivered. Thank you to the both of you. That's Michael Bagraim, who is a member of parliament and a member of the Democratic Alliance, as well as Dr. Nomfundo Ramalekana, who is senior lecturer in public law at the University of Cape Town.